We're with Ryan Tegnelia. Ryan is a criminal defense lawyer in San Diego, California, and he's agreed to answer some online questions that were posted, and they're more or less just kind of tips related to drug charges. So with that said, here's the first question. What's more important, the kind of drug I was caught with or the amount that really matters?
Well, they're both important because, especially these days with the changing pot laws. But generally speaking, if what you're caught with is a controlled substance, whether it's prescription pills that you're not supposed to have on one hand, or steroids on another, or cocaine or whatever, the primary driving factor in your case is going to be how much you have. The biggest indicator of whether or not controlled substances are possessed for sale is their amount. Even if we obviously are concerned about, when we're talking about drug cases, whether it's simple possession or sales. There's a world of difference between the two, especially after the passing of Prop 64, which made most simple possession cases a misdemeanor, and then sales where it's still a felony and prison eligible. And so the indicia of sales that we commonly see are individual packaging, money, text messages that indicate drug sales, scales, and all the stuff that can be used to package it for sale or that indicates that it was broken up and sold. However, the courts have held that an expert opinion, and the expert is usually a narcotics detective from the police department, that quantity alone can be enough. If the person has over a certain amount that that meets the expert's standard, then that fact alone can establish whether or not, can be used by a jury to determine it was possession for sale. Not to say that it's determinative. I mean, like I've argued in court several times, people buy a lot of items in bulk that we don't plan on consuming, right this minute. There's a reason why Coors Light sells 30 packs of beer. So you can make those arguments, and it's certainly up to the jury. But as far as being charged and having to really fight it out, as opposed to maybe with a simple possession, just making it quietly go away, quantity is going to be a huge issue.
Excellent. The next question we had was, can I avoid jail time if I complete any sort of drug program?
The short answer is yes, but it depends on what you're charged with. Kind of going along the lines of that last question, if you're charged with simple possession, and that's it, and you don't have a criminal history, that's too bad. There are numerous diversionary programs that you can do that will not only get the case dismissed, it'll seal your arrest record so that employers won't find it. And there are numerous programs like that that are available throughout the state, as well as some that may be specific to the jurisdiction where your crime took place. But again, that's why it's so important to keep the case, if possible, in the realm of possession instead of having it sort of creep over into the realm of sales. Because once you start talking about sales, a lot of those, most, if not all of those diversionary programs just go away, and they're no longer applicable.
Okay, and the last question we had was, do I always have to carry around my prescription for a controlled substance? And does it have to be the original prescription?
No, you don't. If you have a prescription and you're walking around with it, then that's perfectly legal. Now, that being said, if the officer suspects you of, once again, selling it, then you have a problem. So, obviously, if you're stopped by a police officer and you've got, a bag of 50 Vicodins or whatever, on your person, the officer's not going to believe that you carry that around just because you have a prescription and for your own personal use. But if you have some prescribed medications that you have to take maybe once or twice a day, and you have a couple of pills on you, then that's not going to indicate sales to the officer, and that's perfectly legal. You don't have to have your actual physical prescription on you all the time. As a matter of fact, the police and the prosecutorial agencies, they can access the prescription. They have a database with all the prescriptions in it that can tell them whether or not it's legally prescribed to you before the case is filed against you. But yeah, so there's no law that requires you to carry the actual physical prescription with you. However, as your attorney, I would advise you that it's still a good idea.
Excellent. Well, if you have any other questions for Ryan, just post them in the comments section below. Thanks for your time, Ryan.
Yeah, thank you. And if there are any further questions, anything I didn't hit, feel free to call me at 619-577-0868. Thanks.
Thank you, Ryan.